if it affect a contract, then does it mean that if a policy has been changed and that policy is only affecting some condition of the contract, not all of the conditions?
No,
So in
no.
that case,
Actually, in that case, it will become a void contract, because if
even if
the contract had been signed before the change in policy by the government, right? So if the contract has been formed before any change in the government's rules or in the laws relating to the object or relating to the procedure or any other terms of the contract, then that contract would become void. Because when it was entered between the two parties, it was a valid contract. And later on, the government came up with a rule that made it illegal, for example. Suppose the object was illegal or some of the terms became illegal. So in that case, it would become a void contract.
answer in cap, for like a cap that a company had a like a agreement that that much of amount you have to send the timber, but government a cap that only you cannot send that much amount, but you can send the less amount. So in that case,
No, no,
will it be
it
also
would
void?
not be void, but
Like in a
if
forest case,
actually,
like a company which is a contractor.
if suppose say 2 tons are allowed, for example, to be sold by a particular party, in all such cases, usually what happens, if the government puts up a cap, then it issues licenses to the dealers. And because you cannot exceed that amount which has been sanctioned under or allowed under the license. So if the government allows those licenses, then within that particular limit can be sold by the seller, otherwise not. So any extra amount naturally would it depends on the say buyer. If the buyer suppose wants the whole amount, then perhaps that contract would become void.
thank you, sir.
Yes, any other? Okay, so we'll move to the new topic: legal rules regarding a valid offer. Uh, an offer must be express or implied. Express offer is where the terms of the offer or the conditions or the obligations of the two parties, they are specified in writing, where all the terms and conditions, they are given in writing or by spoken words. So an offer can be, say, verbal, could be expressed by the parties, or it can be implied by the conduct of the parties. Earlier also I gave you the example where express, I mean this offer here, because the offerer, there are two parties, the offerer and the offeree. So the offerer gives the offer, and the offer can be by written words or by spoken words. So that is express offer. Now it can be implied by the conduct of the offerer. For example, there's a transport company and it has a price list of the fares, which are, for example, the government transport company has its fares from Aligarh to say Bulandshahr, and Aligarh to say Noida, and Aligarh to Delhi. So those fares, they are specified. Okay, I mean this particular offer is, I mean, nobody, although it's an open offer, the offer for everyone, and it is specified that this is the price. So this is basically, this is the express offer. But in case of say, I gave you the example of a porter who offers to, say, take the luggage of a passenger out of the station. So he doesn't speak anything. He just takes up lifts the luggage of that traveler and starts, say, taking that luggage out of the platform. So in that case, and the other party, the passenger, doesn't stop him. So this particular offer of carrying the luggage, that is an implied offer. So implied is by the conduct of the parties. So the offer can be expressed or implied. And if the offer is accepted by the other party, then that becomes a contract. So if the passenger doesn't object to the porter not to lift his luggage, then that would become a contract. So that means that the passenger has accepted the offer, the implied offer of the porter. Second is an offer must contemplate to give rise to legal consequences and be capable of creating legal relations. So there must be an intention to create legal relations. And usually family relations or family offering to the family member any promise that would not contemplate to give legal consequences. Like, for example, if and then later on you do not give that particular gift to your friend. So your friend cannot then file a suit in the court of law that although he sang in that particular party, but was not given that gift. So this is just a social relation. But in case of business contracts, in case of business relations, generally the business relations, they give rise to the legal consequences. So if suppose there's the event management company, and that event management company contracts your singer friend to sing in some at some event, and promise a particular amount to him as fees for that. So in case that event management company does not pay the full amount, your friend can go to the court of law for getting the full amount. So this is how this offer, in case of social relations, it doesn't give rise to legal consequences, but in case of business relations, the offers, they give rise to legal consequences. So any offer that's by in a social relation, that is not cannot be enforced in the court of law, but in case of business relations, it will be enforced. Both the parties to the contract, in case of business relations, even in case of business, if they mutually agree that they will not go to the court of law. So in that case, if mutually they agree, then perhaps that offer cannot be enforced in the court of law, even that business offer. But there should be agreement between the two parties. They will not go to the court of law. The terms of the offer must be certain and not loose or vague. Now, the offer is made by the offeree and has to be accepted. The offer is made by the offerer and has to be accepted by the offeree. Now, the offerer would put all those terms and conditions which the offerer would like the offeree to accept. And there should be certainty of performance. There should be all the terms and specifications relating to the performance or relating to the object of the contract should be clearly mentioned. That means the specifications should be clearly mentioned. If it relates to, suppose, a laptop, for example, so the model of the laptop, the RAM, the other features of the laptop, everything, or the storage capacity, everything has to be clearly mentioned in that offer. And there should not be any uncertainty or any ambiguity with respect to any terms and conditions, like, for example, the date of delivery of the laptop, or with relation to the price of the laptop. Even if the price rises in the market, and if the offer is valid for a particular period of time, so that time has to be given. For example, if the validity of the offer that is given in the offer is 30 days, so it's for 30 days. And within 30 days, if the offer is open to be accepted within 30 days, then all such conditions, they have to be mentioned in the offer. There should not be any ambiguity in the terms of the offer. Otherwise, that would lead to disputes between the buyer and seller, or between two contracting parties. An invitation to offer is not an offer. Now, we have to find a distinction between an offer and an invitation to offer. Like, for example, a general offer which may be expressed or which would be in writing or by spoken words, like, for example, and then addressed to a specific party, that would be a specific offer, which we'll take up in the next term, and it would be basically an offer. But an invitation to offer is not directed to any particular person. It's open to the public. For example, an advertisement for an auction of any object. For example, an old car is to be auctioned, and there's an advertisement for the auction of that old car. So everything is mentioned. What is the model number? What is the year of manufacture, and all those terms and conditions are mentioned there. That would be an invitation to offer. So in response to that advertisement, all the persons or parties who are interested in buying that old car, through auction process, would reach that that venue of the auction on that predetermined date, and would then offer their bids. That means the bids would be made. For example, one party would give a bid of say 30,000, another party 35,000, next party would give a bid of 40,000, then another party will give a bid of 70,000, for example, and these individual bids, they will be an offer, not the advertisement. So the advertisement for the auction would be an invitation to offer, and the individual bids which are given by the interested parties, they are the offers. So the highest bid or the highest offer that is made by the bidder would be accepted by the auctioneer or the seller through, when the hammer is stuck on the board. So when the hammer is stuck on the board, that means that bid or that offer is accepted. So individual, that the bids, they are the offers, and the advertisement for the auction, they are the invitation to offer. Likewise, price catalogs or price lists, they are the invitation to offer, and in response to the price list, the interested buyer will then offer to buy those products, and would then state in the offer how many items or quantity of that particular product he would be interested in buying. So that would be an offer. So it would be in response to the invitation to offer. That means in response to the price list. Likewise, in a mall, in a shopping mall, when customers they see the products with the prices marked on the shelves, that is an invitation to offer. And when the customer takes that product for buying, that means to that the person who makes the bill and takes the price, then that particular this customer would be then offering to buy that particular product, and it would be in response to the invitation of offer which the shopping mall had then given as price on the products which are displayed on the shelves. Is it clear? Yes.
Yes, sir.
Okay. Now, an offer must be specific or general. Now, a specific offer is addressed to a particular party, a person, or a company. So a specific offer is addressed to that particular person, that one person. It may be a party, it may be an institution, it may be an individual. So if an offer is addressed to a specific party, it would be a specific offer. And if the offer is addressed to the public at large, then it would be a general offer. Usually, if suppose the buyer wants some product, it would address the particular company or retailer to buy those products. But in case, and that would be basically addressed to that particular retailer or that particular company. However, if in case of general offers, suppose a person has lost his his bag, which is containing his ID and Aadhaar card and everything. Now, there would be a general offer. There would be a general offer by that person who has lost the bag, that the bag contains some very important documents, and which would not be of any use to anyone, and whoever finds that bag will be rewarded, say, 5,000 rupees. So this would be a general offer. It would be communicated by different types of communications, whether by loudspeaker or by notices which are pasted at different places near the supposed place where the person had lost the bag. So that would be a general offer to the general public. And this general offer would be given to the public at large. And whoever finds the bag in response to this general offer, at the time when that person finds the bag, that would be, and the person then brings that bag to the owner of that bag, that would be the acceptance by that particular person. And the moment that person finds the bag, the offer is closed, because no other person can then return the bag, because it's just one bag and one bag was lost. So the person who once the first person who finds that bag, when he finds the bag, the offer is closed. And when he brings the bag, that means he has accepted the offer and would be paid the amount of 5,000 to that person. So that person would be given 5,000. So I mean, the offer, this is how the offer could be general offer to the public. An offer must be communicated to the offeree. Now, we have two parties, the offerer who gives the offer and the offeree. That means the person specified in that particular offer. So it has to be communicated to the offeree. An offer must reach the offeree. That means if the offer does not reach the offeree or does not come to the notice of the offeree, then the offeree cannot send the acceptance to the offer. So, and the contract cannot be made. So it's necessary that the offer should come to the notice of the offeree, and then in response to that offer, then the offeree would send the acceptance to the offerer. An offer should not contain a term, the non-compliance of which would amount to acceptance. So there should not be any such term where the non-compliance of that would amount to acceptance. Like, for example, the offer should not contain a term like it should not be written that if the offer or if the acceptance is not sent within say 15 days, it would be presumed that the offeree has accepted the offer. Now, this cannot be presumed, and like the offer, as in the sixth point, the offer must be communicated to the offeree. Likewise, the acceptance also has to be communicated to the offerer. So the offer should not contain such a term that, like, for example, if the offeree does not respond to the offer, it would be presumed that the offer is accepted. Naturally, either a rejection should be sent or an acceptance has to be sent. And in case, usually, if in response to the offer, if the offeree does not respond, does not send the rejection or does not send the acceptance within the prescribed the time period, then that should there should not be any term that if the offeree remains silent, then it would amount to acceptance of the offer. The acceptance has to be sent by the offeree to the offerer. The offer can be made subject to any terms and conditions. So any terms and conditions can be attached to the offer. So the offerer is free to give any or any attach any terms and conditions. For example, how the acceptance has to be made, in what form it has to be made, or within what time limit it is to be sent to the offerer. So whether it's to be sent by email, whether through the speed post, or whether telephonically it has to be communicated. So any terms and conditions can be attached to the offer, and the offeree has to comply with those terms and conditions in order to make it a valid acceptance. Now, before we go to the next slide, perhaps if you have any doubts relating to these conditions, we may take up. Yes, any doubts? No. Then there's another point. Yes. Two identical cross offers do not make a contract. Now, these two identical cross offers, sometimes it may happen, although it doesn't happen this way, but it may happen that there are two parties, a buyer and the seller, and usually they are dealing with each other, and in the past they have dealt with each other, they have traded with each other. So suppose the buyer needs, for example, 50 quintals of say iron bars, and it may happen that in the past also the same quantity may have been ordered by the buyer from that particular seller, and so the seller sometimes may also offer to sell, say, 50 quintals of iron bar to the buyer. Now, suppose on a particular day, for example, today we have 5th of August. 5th of August, to the buyer sends an offer to the seller that he wishes to buy 50 quintals of iron bars, and the seller also makes an offer to the buyer that I'm ready to sell you 50 quintals of iron bars at this price, and everything matches with each other. I mean, all those terms and conditions to a large extent may match each other. So these are called cross offers because they relate to the same object. The price is known between the two parties because they have dealt with each other in the past. So everything is known, and it is similar in the two offers, but they cross the means. For example, the buyer sends a letter to the seller through speed post, and the seller also sends the letter to the buyer through speed post, and the posts, they cross each other. And on say 10th of or 8th of August, for example, both the parties, they receive the offers. These will be called cross offers, and it will not make a contract, because any offer, if any offer is made, it has to be accepted. So acceptance has to be sent by either of the two parties to make it a contract. For example, all the terms and conditions, they would be same in the two offers, but then the buyer or the seller will have to then send the acceptance So one of the two parties will have to send the acceptance in response to the offer made by the other party. Then only it will give rise to a contract, otherwise not. Yes. Is it clear?
Yes, sir.
Okay. So now we move to the next slide. Sorry. Lapse and revocation of offer. Although we will not be able to complete this particular slide, we explain this particular, we are only left with 3 minutes at the moment. So I'll take 1 or 2 points, whatever I will be able to take up. An offer lapses after stipulated or reasonable time. That means since the term, under the terms of the contract, the offer, it's usually given that the offer is valid for a particular period of time, for 15 days or 1 month, because usually the prices change. So the offer is open for a particular period of time. And after that period, then the offer lapses automatically. If the offer is valid for 15 days or 1 month, then after mode as the of not end speed post, offer would lapse. Or if no mode is prescribed, if in the offer, if no mode, in some usual or reasonable manner, that means by way of sending it either mail or by speed post, these are the prescribed, the usual or reasonable manner in which the acceptance can be sent to the offerer. It does not respond that prescribed mode and in some other usual, I mean other mode, then that can be rejected. That offer would lapse. Otherwise, not. And in that case, if the even if the